All right, good morning, Mr. Graham.
Good morning, sir.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
On April 13th, 2025, law enforcement officers observed a vehicle with an expired registration and conducted a traffic stop. Upon contact with the defendant, law enforcement officers observed the odor of marijuana coming from the vehicle. Probable cause search was conducted of the vehicle and the defendant. Defendant stated he was in possession of marijuana, which was found to be 0.524 ounces of marijuana in his pocket.
Right here, the judge locks in probable cause, and this is the moment everything becomes real for Mr. Graham. Once that gun and marijuana admission is on record, the judge has zero wiggle room. Quick question for you. Should admitting things during a traffic stop be considered cooperating or confessing? Let me know what you think.
Defendant also stated that he had a handgun in the center console. The handgun was recovered from the vehicle.
All right. Can you run his license?
Absolutely, Your Honor.
Mr. Graham, I'm going to find that there's probable cause to go forward with the case. While this case is open, I'm ordering you not to be in possession of weapons. Do you understand?
Yes, sir.
You have the ability to hire a lawyer.
Yes, sir.
Okay, we are going to give you time, so I will have you go to Victoria, sign a reset. We are going to create bond conditions. License?
It's eligible, Your Honor.
Okay, you're not allowed to drive unless you have a license and liability insurance in your name, and that's part of your bond conditions as well. So we'll have you sign a reset. We'll have you go to the box while we get your bond conditions created. We'll have you sign it, and then you'll be free to go. All right?
Sir, thank you.
Please. Thanks, man. Sir, you're charged with racing on a highway. You're facing up to a year in jail. And I'm sorry, you're facing up to 180 days in jail and or a $2,000 fine.
Law enforcement officers observed a large group of performance cars gathered at a location and then saw two of the vehicles line up side by side and accelerate to approximately 100 miles per hour. Law enforcement officers recorded the events, and another law enforcement officer initiated a traffic stop where they made contact with the defendant, who was the driver of one of the vehicles that had took place in this outpacing contest. Defendant admitted to being in the races and stated that he never got out of his vehicle while he was at the race.
Do we have a co-defendant in this case?
They're checking now, Your Honor.
And number one, number two, does he have a license?
I can check, Your Honor. So the co-defendant is not linked in our system.
And this is where the judge turns up the heat. Street racing cases get treated way more seriously than people expect, not because of speed, but because of the danger. Notice how he warns the defendant that jail will be his first move if he That's not drama, that's a legal reality. Have you ever seen a judge give such a direct one more time and you're done speech?
I don't know if they just weren't able to stop that one.
Right.
But I'm running his license now, Your Honor.
Mr. Barber, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to participate in these types of events again. If I find that you do, first thing I will do is I will put you in jail. And the next thing is I will take away your privilege to drive while this case is open. Do you understand?
Yes, sir.
You're not to participate in any street takeovers, racing, donuts, reckless driving, anything of this nature.
Yes, sir. Can I say one thing?
Do not, don't. Just the only other thing I'm going to caution you is you are not allowed to drive unless you have valid liability insurance in your name as well. If you don't have car insurance in your name, you're not allowed to drive, and that's a bond condition as well. If I find that you do without, I will revoke the bond and put you in jail. You understand?
Yes, sir.
Do you have the ability to hire a lawyer, sir?
Oh, yes, sir.
Okay, we're going to give you time. I will have you go to Victoria, sign a reset. We will have you go into the jury box while we get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Yes, sir.
Please. You are charged with assault of a family member. You are facing up to jail and or a $4,000 fine.
Law enforcement officers were dispatched to a disturbance. Upon making scene, they spoke with the 10-year-old daughter of the complainant, who stated that her mom was hit in the face by her dad. The complainant stated that she was struck in the head at least 3 times with a closed fist, while also being kicked on the side of her torso. While this was going on, the defendant had barricaded himself
cerrado
in the children's bedroom
en el cuarto de los niños
of the residence.
de la residencia.
Um, Complainant also stated
También dijo de que
that she was dragged by her hair.
susurraron de su cabello.
The 10-year-old
La
child
niña de 10 años
observed all of this.
observó todo.
The complainant stated
Antes dijo de que
that she felt pain
ella sintió dolor
during this,
durante
but was unable to provide a number
y se pudo dar
on a scale of 1 to 10.
numeración a 1 a 10.
Yes, Your Honor.
Estaba involucrado algo. Dice así, sí,
10-year-old witness did advise that the
niña de 10
defendants
años
have been
dijo
drinking
de
some
que
kind
había
of
dado, había
alcohol.
bebido un tipo de alcohol.
Mr. Mata Rojas, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail.
Te voy a encarcelar.
I want you to know that I will protect every person in my county at all costs. I don't care who you are. I don't care why you're here, how you're here. If you're not in this country with permission and you go to jail and immigration finds you, they will possibly put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with.
Hasta que se acabe el caso.
Do you understand?
¿Entiende? Contesta.
Sí,
Yes.
You're not to have contact with the complaining witness in this case. You're not to be in possession of weapons, and I don't want you to go within 200 feet of where she lives or where she works.
Judge,
Su señoría.
it seems like the CW is going to
This moment is huge. The judge makes it crystal clear that bond conditions aren't suggestions. They're survival rules. No contact, no exceptions, not even divine intervention. As he joked, these strict boundaries are meant to protect victims and prevent the defendant from digging a deeper legal hole. What would you do if someone under a protective order tried to contact you anyway?
want to protective order. I've instructed them if they do, we'll have to come to court and you'll have to see and hear from her if you
I
consider
think the
that.
allegations are,
There might be some self-defense allegations as well.
I get it, but all I know is that at this time, Mr. Mata Rojas, I don't want you to have contact with the complaining witness in this case. I don't care if she comes to you. I don't care if Jesus comes down and says we're having a party and she's there and they want you there. Don't have contact with the complaining witness. Do you
¿Lo
understand?
entiende?
Yes.
Yes.
Judge, if she, after like 30 days, if she wants the protective order removed, would you be open to if she comes to court?
We'll keep an open mind. I don't know.
Yes, sir.
No sé.
All I want to know is that, number one, he's not using, and number two, that she's protected and that she feels that she's not in danger.
Absolutely,
Ella no está en peligro.
So, I mean, come back in a while and then we can talk to her and we'll see.
absolutely.
But until that,
Is his appearance waived? I know your rule, but I just wanted to hear from the court.
Mr. Mata, you have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Martinez, and he will tell you if and when you have to come back to court. If Mr. Martinez tells me he can't get a hold of you because you're ducking, dodging phone calls, text messages, or you pick up a new case, I will revoke your bond and put you in jail.
Te voy a encarcelar.
Do you understand?
¿Usted lo entiende?
Yes.
Yes.
So we have a MOAP that has been already issued in this case, right?
Yes,
Yes,
Your Honor.
sir.
Puesto.
There's a protective order that has been issued in this case. I would get to know it. If you do something to violate this protective order, the state can and probably will file a violation of a protective order. And that is one of the worst misdemeanor cases that you can pick up. For now, we'll have you go to Victoria, sign a reset. You will then get with pretrial for your bond conditions. And after that, you'll be free to go. Thanks, Herman. Thanks for being patient. Good morning, Mr. Cummings.
Good morning, Judge.
So you're charged with deadly conduct. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 11th, 2025, officers were dispatched to a family disturbance call. Officers arrived and met with the complainant. who was ID'd by her Texas driver's license. Complainant identified the defendant by name and date of birth. The complainant stated that an argument occurred between her and the defendant. The complainant stated the defendant grabbed his handgun and held it in his hand as he became angrier. Complainant left the apartment due to fear. Complainant returned to the apartment and contacted the Harris County Sheriff's officers to report the incident. Officers made contact with the defendant. When officers approached the defendant, he stated, quote, "I'm not talking and I don't want to answer any questions." Defendant began to gather his things and grabbed a handgun and placed it in a fanny pack. Officers drew their guns on the defendant, and the defendant stated, "Are y'all going to shoot me? Shoot me then." Defendant complied with verbal commands and was detained.
Is the brandishing of a firearm enough for a deadly conduct? Because does he do anything affirmative? I guess.
So, yeah, and that's, I mean, I would, we're a PC hearing, Your Honor, I'd have to do some case law research, but I can see how it's charged is brandishing the handgun, putting the complainant in imminent fear of serious bodily injury. I think the reason it probably wasn't terroristic threats because there was no word said.
Right.
It was just grabbing of the handgun.
Let's do this, Mr. Cummings. I'm going to appoint you a lawyer today so we can figure out, because, you know, we get down and dirty with every case because I want to make sure if I find probable cause, there actually is probable cause. So let's do this. I'm going to appoint you a lawyer today and I'll have him talk to you and then we'll revisit this PC hearing momentarily. Okay.
Yes.
Just take a seat, but don't leave. All right.
Yes, sir.
And then we'll have you talk to someone here momentarily. Okay. Good morning, Mr. Martinez. Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12, 2025, officers observed a motor vehicle failed to signal a lane change. Officers also observed the motor vehicle's registration had expired in 2022. There was also unconfirmed insurance. Traffic stop was conducted. Defendant was identified by his Texas ID card. Defendant stated he did not have a driver's license nor proof of financial responsibility. Officers learned the defendant was not an eligible driver due to a license suspension back in February of 2024. Officers learned the defendant had 5 prior convictions for failure to obtain liability insurance on his license. Officers asked the defendant if he was aware of his driver's license was suspended, and he advised he was. However, he did not know how it was suspended, saying he was working on his SR-22 and reinstating his driver's license.
Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. I don't care what you have to do in this life. I don't care if there's someone having a heart attack and you have to go save them. There's a burning building and you have to save 50 kittens. I don't care. If you don't have a license and liability insurance, you're not allowed to drive. This is an affidavit that you're going to be signing with me. And if I find that you do, every single time you drive, it's a contemptible action, punishable by up to 6 months in jail and a $500 fine every time you drive. Do you understand? If you want to drive, go get a license, get liability insurance, and I will be doing backflips. So happy I will be to take this off. But if I find that you do, it's really not going to go well for you. Do you understand this?
sir.
You have the ability to hire a lawyer.
No.
I can have you fill an application. I'll take a look to see whether you qualify. Deputy Miranda will give you an application. I'm going to have you come swear to us that you're not going to drive. I'll get you to Victoria, sign a reset, and then we'll have you take a seat. Please.